Today we're going to talk about ethics in negotiation. And I'd like to start out with a quote by Abraham Lincoln, who you know was an attorney and a very successful negotiator who became president of our country. This is what he said to other attorneys. "Discourage litigation. Persuade others to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and a waste of time. As a peacemaker, a lawyer has a superior opportunity of being a good man. There will be business enough." And that still holds true today, doesn't it? Most of what we do as lawyers is negotiation. Unfortunately, in law school, most of the negotiation classes are just considered electives. And some people never even take a negotiation class before they get out in the real world. Think of who you negotiate with all day long. You negotiate with your staff, with your clients, trying to get paid, also with opposing counsel, with the clerks at the court, and with the judge. Everything you do, you negotiate. And then you come home and you negotiate with your spouse or your girlfriend, boyfriend, or your children. So it's very important that we engage in negotiations and be successful with it. Now, ethical negotiators are successful negotiators. They build a good reputation, they act in good faith, and it's a small world that we live in. So it's important that you have a good reputation, that you are trustworthy. Now, what are some of the ethical guidelines that we have in the state of California with regard to negotiations? One is the Attorney General Guidelines of Civility and Professionalism, the Business and Profession Code, the Rules of Professional Responsibility, the Evidence Code, and the California Rules of Court. So we're going to just talk a teeny bit about that now, but there's a lot more that I'm going to ask you to look at yourself. But here we go. It's the Attorney General Guidelines. Here's a couple of the things I pulled out. You must advise a client of informal, consensual, or alternative dispute resolution at the very outset of the case. You must do everything you can to de-escalate conflict. You must not delay, and you have to act in good faith and be honest. Now, the Business and Professions Code also has some key elements. For example, 6016, misrepresenting facts. This is really considered moral turpitude, and moral turpitude is grounds for disbarment. So, for example, let me show you the difference between moral turpitude and misrepresenting and puffery. Misrepresenting would be saying, my client has no insurance, when in fact they have maybe hundreds of thousands of dollars worth of insurance. Or if you say, my client only earns $60,000 when they earn $160,000. This is an actual misrepresentation of facts. Or if you say that there's a case on point and that this case is going to help you win and there is no case, that is, again, moral turpitude, grounds for disbarment. Puffery or puffing is a little bit different. Puffing is when you talk about something with regard to settlement opinion. For example, I don't think that my client can take less than $200,000, and then you settle for $100,000. Or my client is unable to do that. She told me she's not able to do that right now, and maybe she is able to do it later. So that is considered puffery when you're talking about settlement opinion. Now, Business and Professions Code 6128 deals with deception and delay. For any deception and delay, that is considered a misdemeanor. Now, let's talk about some of the state bar rules of professional responsibility. I pulled out 3 to discuss. One is the Rule 2-100, communication with a represented party. You cannot communicate with a represented party without the consent of the attorney unless there is that consent. And that means indirectly or directly. So that would mean by social networking, telling someone else what to say to the client. That also would be a violation. Now, if you're in a group negotiation, you are going to assume that if the attorney is right there and you speak to the client, that that is okay, or in a deposition. Or in mediation, if you're in an open session, you are going to have that ability to speak to an opposing client, but at any time the other attorney can stop it because they can decide when or when you cannot speak with their client indirectly or directly. Okay, the next one would be Rule-3500, communication, keeping your client informed of development in cases. I have been in mediation where the other attorney has not told their client about certain cases or other things that is detrimental to their client. And so that would be a violation. 3-510 is communication of settlement offers. Even if you believe it's a terrible settlement offer and you don't want to get your client upset, you still have a duty to inform your client of every settlement offer and provide copies of documentation, correspondence. Now, if you have a terrible offer and you want to deal with your client so they don't totally get upset or freak out, then you can just say to them, remember, this is an offer, and you can make a counter offer. So you can use all of your skills with your client to negotiate so they don't get upset. The California Evidence Code, and this is an important issue when we talk about mediation, beginning with 1119, we talk about confidentiality. And the beauty of mediation is that anything said or prepared for mediation is kept confidential and cannot be introduced into evidence. However, if everyone agrees and your document states that this may be introduced or this shall be enforceable in a course of law, then it will be enforceable. But until then, you're free to explore options. So that's the beauty of it. But you must remember that you must say in any final agreement that you want to be enforceable, that it shall be enforceable in a court of law. Another important issue deals with California Rule of Court 3.894, and that is you must bring with you someone who has the authority to settle, whether it's the carrier and when there's insurance, or whether there is someone else with a financial accountability. You must bring everyone. I have been in mediation where people have told me that they have brought someone with the authority to settle, but when we get to signing the agreement, they have told me, oh, there's no authority to settle. We have to get the person, he's not here today. We can't reach him by phone or fax. So that is really bad faith. You must make sure that if you want to get a real settlement, that you bring someone with you who has the authority to settle. And I, as a mediator, now always ask, and I make it in writing, you must bring somebody with the authority to settle, or it's a violation of the California Rules of Court and the Orange County Superior Court Rules of Court. I want to leave you with 5 key points to remember that are very simple to help you to have a very successful negotiation, whether it's with your staff or opposing counsel or your client or your family. And you'll remember the acronym POWER, P-O-W-E-R. P stands for preparation. The more prepared you are in terms of knowing the law, knowing the facts, knowing who your client is, what they're going to say, knowing enough about the other client, even knowing about the other attorney, and knowing about the judge, all of that, the more you know, the more you are going to be more successful. And the person who has the more knowledge and is more prepared will be likely to be more successful in the negotiation. The second thing, is options. You need to come in with options. If you only have my way or the highway, you're not going to get a deal. So come in with options that your client can live with, and that will be, several. The options that are best, and then the options that are their bottom line, and have them consider what they think the other party and the other attorney will accept. So the more options you have in your back pocket, the more likely you're going to be able to get a deal. W, worthiness. Worthiness stands for trustworthiness. Are you trustworthy? Does the person, does your client trust you? Does opposing counsel trust you? Can you trust opposing counsel? Do you say what you mean what you say, follow through, act in good faith? That's very important. Because if someone doesn't trust you, you're going to have a harder time getting a deal. They're not going to believe you. Ethics. Don't lie. Don't play games. Don't use tactics that are underhanded. That's very important. And the ethical rules that we've talked about are really important, that you need to constantly be on your guard and vigilant about being ethical, because that's your reputation. And your reputation will follow you the rest of your life. So that leads to relationship. You want to build good relationships. You're going to see these attorneys and these mediators and these judges and clerks over and over again. The more you build a positive, congenial relationship, the more you're going to be respected, the more they're going to want to work with you, the more you're going to get for your client. So I want to leave you with this quote by retired Chief Justice, U.S. Supreme Court, Warren Burger. He said this in 1984 when he was speaking to attorneys. He said, "Lawyers, judges, law teachers, the entire profession has become so mesmerized with the stimulation of the courtroom battle that we tend to forget that we ought to be healers of conflict." I want to recommend to you that you consider yourself a healer of conflict, that you go into a negotiation or a mediation with the mindset that you're going to settle. Be prepared, be congenial, use the leverage that you have that's fair, and get a good deal for your client. And you'll be a healer of conflict, and they'll appreciate you. Thank you so much.